Okay, well, we do have quite a bit to get through. I'm hoping
Only
we've got
70
a lot of
something pages.
pages. We've got a lot of pages, but I think the material we can get through. Um, a lot of it's I'm not going to say repetitive for what we've been talking about, but we're building principle on principle. So I'm hoping we can get through chapter 7 today.
Yeah, we left off on page 217. So I don't know if we really got through this whole page or not, but there was
No,
a lot of conversation at the end. So
yeah, we kind of did that, and we ended because with the book's got this Dykes versus Arnold, and it takes up about 20 pages here just to get through the court case. But um,
yep.
ultimately, I thought we would jump to the end of the court case because I think we covered kind of the intent there. We talked about the re-breaking down or redividing of sections and why that's not needed and that's not part of the private surveyor's purview to do. And so where I kind of want to start is just to 234 and just kind of read the synopsis here at the end of the court case and then see kind of where our discussion leads us, if everyone's okay with that. Unless, Jeff, if there's anything out of the court case you want to point out or anyone else wants to say anything about that before we jump into the book.
No, I don't think so, PW. I think we can move on.
Okay,
Definitely
great.
important. It's definitely an important case, but
Yeah, but I think, like I said, I think we've covered an overview of that and what our role is as private retracement surveyors. Um, so it says here, just to kind of close this out, the Dykes case is extraordinary in that it contains many of the details we need in order to analyze the surveying activity against the law that is pronounced in the case. This is not always the situation. Court opinions often leave the reader wondering about some aspects of the case and how the law would be applied in factually different scenario. Change the fact scenario even slightly, and the outcome in some future cases could be considerably different. The Dykes Court gave us some valuable lessons on the interpretation of case law when it discussed the other cases that it considered analogous to its own. Um, and then Jeff talks about, one thing it didn't clearly state, but is kind of implied is in retracing the section, did he reestablish the quarter corners or was he able to find the original ones? And that's kind of where we ended our discussion last time as we were talking about kind of reestablishing a center quarter corner and proportioning that in and looking at the evidence. And so what I wrote here, I just kind of wrote this in my book, and I think this fits, is as we talk about retracement, we talk about gathering evidence. The one thing we really do need to keep in mind is the manual of instructions for us as retracement surveyors is not a how-to book. It is a piece of evidence. It is there to help us understand how these original sections were broken down and how then to get to the best evidence of the original corners. And so I wrote that in my book here is the manual is a piece of evidence. It is not a list of instructions.
Yeah, and I do want to point out, PW, that when I was writing this book, the 2009 manual had not come out yet. And so, and then there's a lot of things in the 2009 manual that we really, really didn't get to in this book because I was reading out of the 1973 manual. Then I was finding the cross references over to the 2009 manual, basically um, indicating that there wasn't much change. But actually, there were several things that I discovered later after I wrote the book that were very interesting. And if I ever do a second edition, I'll include them. Um, and I wanted to talk about them tonight, if possible. There's just a few sections here that I wanted to go through that's in the 2009 manual. If you think that that's appropriate, if you don't want to get off on a tangent, we don't need to. But
Oh,
uh,
I think that's great. We'll let you
yeah.
take that and run with it. Absolutely.
all right, let me share my screen then.
Yep. Let me stop.
Let's see.
You
How
are
do
good
I
to go.
share?
You're
Okay.
good.
I shared. Okay, right here.
It's
Do I
coming up.
see a slideshow presentation?
It's up right now. Yes, sir.
All right. So I'll run through this. And stop me when you want to, talk about something. But out of the 10th Circuit case of United States versus Doyle, the original survey is actually run on the ground controls, even if the survey was done incorrectly and the boundaries are in error. And we've been over that kind of thing before, but for this little presentation, I thought that's interesting to keep that in mind as we move forward. So section 1.1 of this is the 2009 manual. Corner monuments on the ground established actual on the ground location. For the boundaries of the lands entered, patented, and or otherwise conveyed, the process assures the orderly disposition of the public lands and avoids confusion and contention. Moving on to chapter 3, by law, the corners marked on the public survey shall be established as the proper corners of the sections or the subdivisions of the sections. So, one thing to keep in mind as we're moving through these few slides is who was in charge of the subdivision of the sections. Generally speaking, that was not the BLM surveyors. They didn't do the subdivision of the sections. Of course, they could have if they had special instructions, but they didn't. And we've already maybe discussed it to a certain extent. It was the local surveyor's job when hired to do so to actually subdivide the section. So keep that in mind as we go through these few slides here. 3-4, subparagraph 2, the boundary lines actually run and marked shall be and remain the proper boundary lines of the sections or the subdivisions for which they were intended. Again, the intent of the federal government was that the local surveyor would be hired for the purpose of subdividing the sections. And the lengths of the lines as returned shall be held at the true lengths thereof. 3-133, here's the local surveyor. Now we got the local surveyor involved. The function of the local surveyor begins when employed as an expert to identify lands which have passed into private ownership. This may be a simple or a most complex problem. Anyway, the work of the local surveyor usually includes the subdivision of the sections into the legal subdivision shown upon the approved plat. In this capacity, the local surveyor is performing a function contemplated by law. He or she cannot properly serve the client or the public unless familiar with the legal requirements concerning the subdivision of the sections. 3-135, the Bureau of Land Management assumes no control or direction over the acts of local or county surveyors in the matters of the subdivision of the sections. Evaluation of evidence of corner locations and reestablishment of lost corners of original surveys where the lands have passed into private ownership, nor will the Bureau of Land Management issue any instructions. 3-99, the public land survey system. A corner is fixed in position by operation of law. Corners marked in the official surveys followed by the use are fixed in position by monuments. Only a small portion of the corners are marked on the ground in the original surveys. Subdivision of section corners are generally not marked. Their position is fixed on the plat by protraction, and their positions are fixed on the ground by the survey process of running and marking the lines between the marked corners and setting the monument. Now, who does that? That's the local surveyor. 3-137, the protracted position of the legal subdivision corners on the survey plat is merely the first step. So they draw the lines on a map. And in the typical section, the lines will be drawn, or even if they're not drawn on the plat, they're contemplated that you would have 4 quarters, and each quarter would be taken down to 4 quarter corners. It gives you 16 lots. That gives you 25 corners, and the Bureau of Land Management only set 8. And so, how were the other 17 supposed to be put on the ground? The protraction The protracted position of the legal subdivision corner on the survey plat is merely the first step. They draw the lines on a map and fixing the position of the corner. The corner position is fixed by running and marking the line. Somebody had to do that. A decision to set aside a previously fixed local survey legal subdivision corner. When that local surveyor was hired to go out there and run and mark the subdivision of the section on the lines, they became the legal subdivision corner. Must be supported by evidence that goes beyond mere demonstration of technical error, reasonable discrepancies between former and new measurements, and less than strict adherence to restorations of subdivision rules. 3-137. Were the federal government obliged to open the question as to the location of a particular tract or tracts over technical differences or reasonable discrepancies, controversies would constantly arise and resurveys and readjudication would be interminable. The law gives these activities repose. You see that word repose right there? I'm assuming that the Bureau read a little bit of Cooley between 1973 and 2009. As far as I can tell, that's the first time the word repose has been used, and that's in the manual, and that simply means it's already been done. The section has already been laid out. The federal government came out, laid out the framework of the section, and then the local surveyor was to be hired. This is the intent of the federal government. We talked about this earlier in this chapter. The intent was that local surveyors would be hired to come out in a good faith effort on the part of not the surveyor, on the part of the entryman, the claimant, or the patentee in finding their good faith location, in finding their location in good faith. And what is the opposite of good faith? The opposite of good faith is bad faith, meaning basically fraud. It's hard to prove fraud today when you go into court. Usually, it's that it has a higher evidence standard. It's usually clear and convincing, somewhere between a preponderance and beyond all reasonable doubt. I mean, it's very difficult to charge. It's like an adverse possession case. It's clear and convincing evidence. The burden is higher. It's very difficult to get it to charge someone with fraud and actually carry out the charge. And we're talking about, in most cases, we're talking about fraud that was perpetrated over 100 years ago. How can you prove fraud in the original entryman, on the part of the original entryman 100 years later? You can't. This stuff is supposed to be left in repose, according to the manual. We're supposed to leave these subdivisions in repose, leave them where they're at, not breaking them down again. 137.
Well, Jeff, can I stop you there just a second here? I think that's a good thing, pulling us just a little bit into the chapter here, is you're talking about these levels of evidence, and it's almost at the end here where it's actually mentioned the the clear and convincing evidence that was in the 2003 manual, and the 09 for the first time kind of steps away from this clear and convincing, and the book talks about the as retracement surveyors, how hard it is to get to this level of evidence that it's a lost corner, right? Because all of a sudden you have all these people that have been occupying to it for 100 years, and maybe speak to that level of evidence again a little bit more in the retracement sense.
Yeah. Well, I think the idea of the clear and the beyond all reasonable doubt. It was sometime. It was that first circular that came out, I think, on the circular on lost and obliterated corners, like in 1893 or something like that. Clear and convincing, but the Bureau never. And this comes from some court cases and some administrative law court cases. And I can't quote them off the top of my head, but basically, and it's in the book. what is it? The IDLA, interior. Um, um, I, I'm not looking at it right now, but anyway, the 2009 manual. One of the changes that they made was they changed the evidence standard from beyond all reasonable doubt, uh, uh, proving a corner um, merely obliterated as opposed to lost. Um, they changed it to substantial evidence for the Bureau's own uses, changed it to substantial evidence, which is less than a preponderance of the evidence and more than a scintilla. Substantial evidence is a lower standard, whereby the tendency would be to call corners merely obliterated, not lost. I mean that's the purpose of it. We're not dealing with lost corners. We're dealing with obliterated corners. But as I said in the chapter and brought the attention to in the chapter, when the 2009 manual came out with that lower standard of proof, lower evidence standard. Some in our survey community thought, well, that's great. Now all we have to do is apply substantial evidence to a corner, which is good you can do, but that does not change the civil standard. And when you go to civil court, the civil standard will still be a preponderance of the evidence. So the BLM manual can't dictate civil actions. That's what the Barrett case talks about, which is also in this chapter. Our standard as surveyors, especially private practice surveyors, our standard of practice will be judged at by a preponderance of the evidence, which is still pretty low. I mean, if you think of when you were back in grade school, you had to get a 70 on a test to pass, right? Well, a preponderance of the evidence means a greater weight of the evidence, more than 50%. All you need is a 51 to pass the test in retracement survey, if you want to put it in those kinds of terms. So all you need is a 51 to pass the test. More and better evidence than the alternative to your survey. So, and when you go to court, generally speaking, not always. There will be over a boundary dispute. There'll most likely be two surveyors, and one of them's going to be a winner, and the other one's going to be a loser. And for what ought to be obvious reasons, you want to be the winner because there's less collateral damage as the winner than as being on the losing side. And so that's what you need to be, thinking about when you do any retracement survey. I always think about, well, what's going to happen if I end up in court? And I want to have more and better evidence than the other side's going to have. And I'm currently working on a couple of columns for XYHT magazine. I'm not in there as often as I'd like to be, but I'm currently working on this issue that I'm talking about right now, going to court, and what does it take, to win when you go to court. And
Jeff, if I can pause you right there, Corey threw into the chat, what is the difference between preponderance and substantial? I think you've been answering that, but I just want to make sure as we move on here, and we're covering evidence, that Corey has his question answered. If you had any follow up to that.
Sure. Just imagine a scale that down here at the bottom is 0, and the scale goes up to 100%. Right down here, almost no evidence, sometimes referred to as a scintilla of evidence. That's almost no evidence down here on the scale. You go up about halfway, and you're at the greater weight. Okay, about halfway, about 51%, technically speaking. 51% would be the greater weight of the evidence. Somewhere between a scintilla and the greater weight of the evidence, or the preponderance of the evidence, right in here somewhere. It's not a bright line. That's substantial evidence. Okay, it's more than a scintilla. It's less than a preponderance. And then Up above the preponderance, all the way up is our criminal standard, and that is beyond all reasonable doubt. And that was the standard that was in the BLM manual for 113 years. They finally changed that in 2009. So somewhere between a preponderance, the greater weight of the evidence, and the criminal standard of beyond all reasonable doubt is clear and convincing. And that's used, a lot of states will use clear and convincing adverse possession cases, criminal fraud, clear and convincing evidence. You can have not civil fraud as well, not criminal fraud. But usually that's a higher standard of proof that you're going to need. So anyway, so all you need is more and better evidence than the other side. And here's the other key to winning in court. I'm not saying, I've been on the winning side every time I've been in court, but the other key is being able to explain why you did what you did. And that's the big, anybody ever, have you ever seen that TED talk by Simon Sinek, where he talks about why, the why question? Well, the why question is very important when you go to court. Most surveyors can say what they did, they can say how they did it, but they can't answer the question, why did you do it? They can't answer that question. And that's what the judge wants. That's what the judge wants when you go. And I know you got me way off topic here, but anyway, that's what the judge wants. In a boundary dispute case, at least my experience is, the judge doesn't want to be in that case, especially when surveyors show up, because surveyors get on the stand and they talk nonsense, and they talk about stuff and use jargon, and they talk about stuff the judge can't even understand, and you lose credibility. You lose credibility, you're done. It's over. But what most surveyors can't do, and this is even in cases that I just read that I haven't even been involved in, the surveyor can't explain why he did, what he did. Well, I just found some sticks and stuff, and that's what I held. That says nothing. That says nothing. So you need to be able to explain why you did what you did, and you can, of course, do that with notes, and that comes back to the boundary location doctrines and why you held the position that you held. And the other and this is reason that what I'm going over here, these few slides here, is the reasoning behind why I'm not going to go back and break a section down all over again if it's already been broken down. The manual doesn't say to go out there and break it down again. And that was what was happening in Dykes versus Arnold. Oh, we've got to break the section down because that's what the manual says. 3-87, you got to run the north, south, east, west center lines, and that's how you get the center quarter. Oh, yeah, really? No. 3-95, 1973 manual. That's what you do. That's how you set the center quarter unless it's already been set. Same thing with the center of any of the quarters, unless it's already been set. If it's already been set, then the assumption is that that work has already been done. And plus, it doesn't pass the common sense test. How many times does a chunk of dirt need to be subdivided on the ground?
Just once.
The only common sense answer is you subdivide it once. So anyway, let me just finish this out real quick, TW, and I'll be done here.
Oh, keep going.
So federal law, the federal government can't go in there and break the section down all over again because federal law won't allow the Secretary of the Interior to do that. In 635, it may be held generally that a claimant, increment, or owner has located his or her lands in good faith. It's all about the people. It's nothing about the surveyor. There's nothing about surveyors in this part, bona fide rights and good faith efforts. There's nothing about the surveyors in here. Has located his or her lands in good faith location rule if such care was used in determining the boundaries as might be expected by exercise of ordinary intelligence under existing conditions. And that's what I was talking about with John Mark, the very first patentee. What was he supposed to do? How was he supposed to get his boundary line set? By ordinary intelligence under the existing conditions. And 100 years later, we can guess what ordinary intelligence would be, like hiring a local surveyor. Okay, that would be the ordinarily intelligent thing for a landowner to do. Let's just go hire a local surveyor if there's one around, and have them, set that center quarter. And then the only way that the landowner could be charged with fraud is if there was some affidavit somewhere that he and the surveyor that he hired conspired to not set the corner in good faith. And we think that it wasn't set in good faith because just like Derek in Dykes versus Arnold, Derek stubbed it in. He ran from the east quarter corner. He ran through the section to the west quarter corner. Got a falling on the west quarter corner, and then he came back on true line and he stubbed it in at the midpoint between on that one line. And so and how does that prove fraud on the part of the entryman? It doesn't. We're trying to throw Derek out. Derek's he was a county surveyor. He was the first one to the center. He did everything that the manual asked him to do. And then we're throwing him out. Every time I broke down a section when I was down in Florida, growing up as a young surveyor, I was breaking sections down all the time. I had no reason. I didn't know why I was doing it. But I was doing it because that's what I was told to do. And they just didn't pass the common sense test eventually. And that's one of the reasons I went to law school. I wanted to find out more about surveying. Ordinary intelligence under existing conditions. It's the good faith location rule. The good faith location rule. And United States versus Doyle. This is just it was in federal court, probably because of diversity of ownership, the United States versus a local Doyle. A precisely accurate resurvey cannot defeat ownership rights flowing from the original grant and the boundaries originally marked off. One more slide. United States versus Sitco. When these things go to federal court, federal law isn't involved. Just so you know, federal law isn't involved. When you end up in federal court because of diversity of ownership, the United States versus Sitco, a local citizen, the property law of the situs state, in this case, I think it was Wisconsin, or maybe it was Minnesota. The courts apply local state property law. Okay. And the only reason they're referring to the manual in this thing is because in Wisconsin or whichever state this was they had stuffed the manual in their statutes like so many Western states have done, or by reference or whatever. But anyway, it does not matter that the boundary was incorrect as originally established. As originally established by who? The local surveyor. So anyway, those little jewels are in the 2009 manual that I really didn't address in the book, and I've taken this way off course. I'm gonna stop and share. I might even shut up.
No, keep going. This is great. This we were going to cover a lot of this today, so this is wonderful information. Any questions for Jeff about the 2009 manual or some of his 10 commandments there before we jump back into Pincushion? Okay. Great. Thank you. Jumping in here, so I am jumping down, Trent, to the bottom of 236. We start talking a little bit about acquiescence, and really in this case we're really just trying to get to kind of the good faith or the bona fide rights of the entryman or the current occupants, right? It's been established for 100 years, and someone bought it again in good faith that this is what was represented. It was bought, it was laid out correctly, and I really like kind of where it starts going here. So right here it says, not only is acquiescence a boundary establishment doctrine, as discussed in chapter 5, is also an evidentiary tool that the courts will use to determine the true location of a section line. Again, this idea that we're not re-breaking down the section, is if it's been acquiesced to or occupied to, it becomes true, right? Or any subdivision thereof. The Wisconsin case of Northrop versus Opperman, decided by the Wisconsin Supreme Court in 2011, is instructive on this aspect of acquiescence. I think of all the court cases that we read through, the first few paragraphs of this are the most clearly written court cases that I don't like zone out to as I try and read through there. I think these first few really just kind of sum up my understanding of it. I'm going to read real fast the second paragraph in the court case. Insofar as boundary disputes are concerned, we are unable to discern from the cases any functional differences between acquiescence and estoppel. These two terms do not represent separate doctrines or concepts. Acquiescence is a condition of fact, if proven, results in an estoppel against the party who has acquiesced. No attempt is made to include here an exhaustive list of the formulations, terminology, or categories used by this court in the numerous boundary dispute cases. Instead, we have included a number of more commonly used formulations to illustrate the language used in our case law to resolve boundary disputes and the historic inability of the court to consistently classify boundary disputes into doctrinal categories. So they use this estoppel and acquiescence. And I really kind of like that approach to it, is when properly applied or determined, estoppel can be applied to as it says, estoppel against the party who is acquiesced. It's been relied upon. You can't change what's been there. So it's just reaffirmed.
I just wanted to reiterate, acquiescence, we've talked about it on many occasions as a boundary doctrine. The acquiescence of the people, into the boundary helps establish the boundary. But also, what this case was all about was acquiescence was also used as a evidentiary tool. The people's acquiescence into the road, I think it was Lynn Road Lynn Road, as the section line was better evidence than later surveys where surveyors in the case used a double proportionate measurement to reset section corners, and then they weren't on. And what happened is in the 1800s, 1850s, in this particular case, the GLO surveyors came out there and they set the section lines, and then 20 years later, the local town condemned for Lynn Road, condemned so many feet each side of the center of the section line. So they condemned the road, and then the next thing that happened after that is they built a road. And when they built the road, then all the evidence of the original corners was destroyed along the way. And then in 1912, county surveyor, the county had to told this county surveyor to go out in this area of the county and find the section corners. And so he does some proportionate measure, and he's not even on the roads any longer. And there are a couple of court cases that happened, and Lynn Road was adjudicated as on the section line. And then 100 years later, all starts over again. County surveyor goes out there and finds the 1912 survey, and that's not even on the roads. And so it was a big mess. Lawsuits were getting filed. This one happened, and so Shirley Abrahamson, Chief Justice for the Wisconsin Supreme Court at the time, wrote this opinion, and it's like, this is like surveying 101. I mean, this is like must reading for any surveyor. She got it, and I actually contacted her office after I read this opinion, and to talk to her. And the secretary was, well, what do you want to talk about? Well, I want to talk about this opinion she wrote. Well, she can't really talk about that. Well, I won't talk about the opinion then. I just wanted to tell her, just to speak to her and say, it's a brilliant opinion. And so I was like a little schoolboy, on the phone with her. And she was very nice. She was very understanding. And uh, you know welling up, and ready to cry, because this case is just, she and I just said, she gets it. And not every judge who writes an opinion really gets what it's all about. And she really got it on this one. So the acquiescence of the people into the road for 100 years was better evidence than these surveys that surveyors were doing.
I like it. I like the image of Jeff Lucas fangirling over a Supreme Court judge. John's got his hand up, but there's one other thing that I had highlighted here and I kind of skipped over. Try not to read through all this, but it does say here in the middle of this page, sometimes the word is seemingly used to mean that the conduct of the parties in acquiescing, that is agreeing to or complying with the boundary line, constitutes the best evidence of the boundary line. The word acquiescence is thus used to mean that the conduct of neighbors is evidence of a boundary line. And then right under that, the doctrine of acquiescence has also sometimes been referred to as rules to practical location. That's where they've occupied to it. That's the best place it should be. So that's another great line in there that helps out. But John, you've got your hand up, so I'll let you go ahead and take it there.
Yeah, I was just going to comment and Jeff is right on with this. This ruling is a fantastic one, but there are some local variances in some of this stuff. But acquiescence is, from an evidentiary standpoint, really kind of has its fingers in a lot of these different doctrines, like the practical location and even agreement, everything. But her comments on estoppel were kind of interesting to me because she's talking about how, once the boundary line is fixed under any one of these boundary doctrines, then the parties are stopped from claiming to some other survey line or other line that they might think, because the line has been fixed. So they're all, so the end result is this estoppel. But here in Utah, we've got a specific, several cases actually, that really differentiate the acquiescence from an estoppel, and look at estoppel as one of the doctrines itself. They call it boundary by estoppel, where you have a representation made by one of the parties, the other party relies upon the representation that's being made, and the boundary line becomes fixed, not necessarily by a mutual acquiescence or agreement, and doesn't require any long period of time. It's just that you made this representation that here's the boundary. They've now relied upon that, made these substantial improvements based upon that, their reliance upon the representation. Once they've made those improvements, it's too late to go back and change your representation now, and undo all the stuff that they've done. They're too committed, more in cost, dollar amount, things like that, rather than a time period. So the doctrine of estoppel has been used that way here, and it makes perfect sense. One of the cases was a case of Dahl versus Hughes, it's called, here in Utah, and the parties had. There was an old fence line that was later adjudicated as the boundary. It'd been there for more than 20 years and was the boundary because it'd been acquiesced into for a long period of time. But the front part of the fence had deteriorated, fallen apart, and was no longer in existence. The people had a survey done that, of course, showed the fence in the wrong place. So they started building a cobblestone driveway and laying cobblestone bricks up to that, to the where they thought the boundary was. And as they were laying these bricks, they were doing it at night, and over a period of 18 months, actually, they finally got this cobblestone driveway constructed. Well, then the parties came to them and said, you came past that old fence line that used to be there, and that was where the boundary really is. And so they claimed that now they've encroached. But during that 18-month period, they watched them put in this driveway and never said anything until they finally brought in a lawsuit over the old fence line, and proved that, yeah, the old fence line was the boundary, sure. But in the meantime, because of the situations, they had allowed them to construct this driveway over that line or beyond that line, and the courts now has stopped them from claiming that the fence line was the boundary. So you got this surveyed line, then the acquiesced line, and now the estoppel line, and ended up with a 1.65-foot jog in the dogleg jog in the fence in the boundary. Follows the cobblestones and jogs over 1.65 feet at the end of the driveway, and then continues on the old fence line. It's the acquiesced boundary. So interesting application. Just a representation by one, reliance by the other. And substantial costs incurred. This is about all that is required to prove it.
Okay, yeah, thanks, John. Hey, I mean, you could say in that case, to kind of pair in what this Wisconsin court case saying, they acquiesced to it through the construction of it, but the Utah court cases have stopped to it. So
Yep.
I love that connection there to that language. Thank you.
John mentioned 20 years. 20 years to somewhere between 20 years and 30 years. That's a kind of a magic number. We would do, as surveyors, retracement surveyors, we would do well to not upset the apple cart, not upset the status quo when things have been in place for 20 years, 30 years, 100 years, obviously. Because what's general, at least my experience has been, um, being involved in court cases, being involved in writing about cases, is generally boundary dispute cases are started by surveyors. At least this is my experience. They're started by surveyors or a survey that upsets the apple cart, upsets the status quo, and then we go into litigation. And what usually happens is, it's not called the common law because it makes common sense, but common sense prevails, and we go back to the status quo. And so, why even upset it to begin with? There are plenty of reasons to maintain the status quo as the land surveyor, and plenty of ways you can explain why you did it. What surveyors seem difficult coming up with answers on why is when they upset the status quo. Why did you upset the status quo, Emerson? Butler versus Coyle. Why did you, Mr. Emerson? The meets and bounds description called for Lane Road as a monument. Why did you go beyond? Why didn't you hold Lane Road? I don't know. The computer made me do it. Well, that's not a why. That's not even a reason. That's an excuse.
Well, I would go as far as say too. Sometimes even if we're in attempting to hold the status quo, we forget, the what a clean title looks like. We will claim acquiescence. It's acquiesced here, but the challenge there is sometimes we talk about these principles, but we don't talk about the what's next. And kind of brought that up in here before is just because we find a case where acquiescence applies or likely applies, sometimes there needs to be something that happens to clean up title, and we remove ourselves from those next steps and perpetuate problems that should be cleaned up, and we recommend and help our clients do it. And whether we're on the acquiesce side or the encroach side of the survey, how we approach our clients with that and help resolve it and monument those changes in title is, I think, a critical spot that gets missed in these discussions of the what's next as far as surveyors and how to help our clients clean this up and fix their property so that it's not perpetuated.
Yeah, solving people's problems as opposed to generating problems they didn't even know existed.
Yep. Okay, so then we jump in here. We've talked about this quite a bit here. 704, good faith and bona fide rights. Um, and again, I'm just going to kind of read through here some highlights. We've been talking about this, but the top of 242, the next page over there, it says the manual provides an excellent explanation of the concept of bona fide rights with regard to retracement work. And this 612 right underneath there. In order to carry out the provisions of laws relating to resurveys, the surveyor must understand the meaning of the term bona fide rights and under what circumstances it will be held that such rights have been impaired by a resurvey. That no such resurvey or retracement shall be so executed as to impair the bona fide rights or claims of any claimant, entryman, or owner of lands affected by such resurvey or retracement. So again, we jump in and out of the manual of instructions here, but I think we pick and choose what we want to pull out of here sometimes. And even in the manual instructions, when it's giving instructions to the government surveyors, they're telling them that, hey, we need to respect the bona fide rights. The enteryments come, they've occupied, they had good faith in doing so, so they can't interrupt those rights, even less so than can we, who are just retracing in the private sector. Jumping over to 705 here, retracement surveys. Again, a lot of the same stuff over and over. It says there are no original surveys, no new lines are established, and no new corners are set. Retracement surveys constitute the vast majority of surveying work that the private practice surveyor will be hired to perform. The only time the land surveyor will not be performing a retracement survey is when the surveyor is laying out new lots for a new subdivision of land for the very first time. And even in that, we have to do a retracement first to establish the bounds that we are going to work within, and we can subdivide internally to that parcel or parcels and be an original surveyor inside of that to lay out new lots and become the original surveyor inside of that. But we still have to do a retracement of the exterior of that to know that we're working within the proper bounds of those parcels or parcel. Let's see here. The manual contains a definition of a retracement survey in 6.7. A retracement is a survey that is made to ascertain the direction and length of lines and to identify the monuments and other marks of an established prior survey. Retracements may be made for any several reasons. And here in Utah, the state has released grants. They're called MRRC funds. They're monument retracement funds. So for our lower class counties that don't have staff surveyors or funds to do this, they've released where you can go to the state, get a grant to go do retracement surveys of sectionalized land. And what we're doing is we're establishing or finding or documenting with a corner record obliterated or even existing section corners that don't have good documentation. And so I do one in a northern county here. We're working with the county recorder who acts as a county surveyor there, and we've been kind of subcontracted to go out and do this retracement survey of the sections. And so we're going through section by section through the county or township by township with the grant money. And it's been really fun because we went out there and we spent a couple of weeks out there and we just found every corner we could, just the easy ones to find. Ones that had corner records, surveys that referenced them. Just went and searched in every corner to see what we could find, and we pulled all that evidence in. And then the next step, I really feel like some of these old government, dependent or independent resurveys of going through here. There are corners that are obliterated, right? They're not, the physical monument is not in for the corner. And it's been fun to go, okay, what evidence can we find of occupation to that? So we're shooting fences, we're actually retracing surveys and subdivisions, and we're stacking all this evidence on top of each other to find the corner. It's not just the northwest corner's in and the southwest corner's in, and we're going to do a perfect middle of that to go reset the west quarter corner. We've had to go establish other centerline monuments and surveys and stuff to establish the best location. And they're not always in where you would expect them to be at the perfect 50-50. And so that's what this is saying is there's so much evidence in retracing even section corners in this case, but even private property corners in the work that we do. And it's not just breaking down section corners. So I've had a lot of fun this year doing this. My first year, the company I work for has done it for a few other counties. This is my first year doing it. And it's been really great to go out and traipse through farm fields and go find old corners in areas that don't normally get surveyed. And it's been really fun to retrace and really get into some of the principles here and not just go re-break down the section, because that's what we're tasked to do. We're really tasked with retracement. Jumping over then now to 706 evidence standards. And we started getting into this before, and the reason I kind of stopped Jeff when he was talking is the next two sections, 706 and 707, is the best available evidence. He was kind of hitting on that in his presentation there of what it is. We had some great discussion. Kyle threw into the chat here kind of this pyramid of evidence standards, which was really great. And so okay, I could kind of stop because it says here, one of the problems with the 1973 manual is the beyond reasonable doubt evidence standard that it expressed for lost and obliterated corners. And in the private resurvey, I mean, we've certainly got some areas that are in the private ownership that are very rural and there's very little evidence. You know, it's just sagebrush and no fences have been put in. And, you know, there's definitely a lot of applying the manual in those areas that might apply. But I think by and large, most of the surveys we do for someone that hires us, there's some sort of occupation there. There's some reason they want to go establish it. I would go as far to say that there's probably quite a bit of evidence that we should be able or could find in retracement in our everyday kind of standard survey work. So standards of evidence, we've talked about this, but the different types of corners. So an existent corner, section 5.5 says an existent corner is one whose position can be identified by verifying the evidence of the monument or its accessories by reference to the description in the field notes or located by an acceptable supplemental survey record, some physical evidence or testimony. And that means a lot of corners that we probably call obliterated really could be existent. I mean, there gives a wide array of evidence that you can use to reestablish a corner or call it existent. You know, some physical evidence, testimony, supplemental survey records. So someone else at some point in time has surveyed that corner of the section and referenced it. Well, that corner is likely existent because you can go retrace someone else's survey to go find it. I think it's pretty hard to get out of that existent area.
Brent,
Yeah.
you mentioned something, oral evidence, which is probably the most important evidence that is most ignored by retracing surveyors. And when I say most, I'm talking about 20 years of studying court cases, writing about court case, post law school. And there's a character I have in when I go over these cases, like in a presentation or my mock trial. Both of my mock trials, I have this character. He's called Old Timer. And Old Timer is that guy who, knows everybody's business in the neighborhood, but also knows a lot about the property boundaries. And in many cases, it's Old Timer who actually solves the boundary problem, testifying in court as to what he knows about the boundaries. And that's probably United States versus Sitka. Two Old Timers showed up in that case. Okay, and that was the determining factor. And that's probably the most important evidence that surveyors ignore the most, if that makes sense.
Yep. And probably I'll even go add to that, Jeff, is not just ignored, but not sought after. We just want to go out and do our survey, and we don't go ask for that information from the neighbors or the old timers.
Yeah, well, I can tell you how you can find every old timer in a 15-mile radius. Is you go out and you park on the county road there, and with your signs on the side of your truck, you drink your coffee, and you'll get the low hanging fruit. They're going to come by and say, what you doing? Are they going to widen the road? So if you want to expand your reach, what you do, you're not getting enough old timers. You get out of your truck, you set up your tripod and put your instrument on top of the tripod standing out there next to the county road. And then you're going to get every old timer in a 15-mile radius is going to stop and ask you, are you going to widen the road? So they will talk to you. And this is one thing when I spent a long time trying to be a survey manager. And then herding cats and pushing rope. Post law school was right. I was finishing up law school in 2001 when 9/11 hit, and the company I was working for basically closed their doors, and I went into solo practice at that point in time. I still wasn't quite out of law school, but I started a solo practice, and I was just flabbergasted by how much evidence was I had been missing because I wasn't out there in the field actually gathering the evidence and talking to people. It became my MO to actually seek people out, or at least make myself very available to discuss things with locals. And I'll always try to get my client to walk the boundaries with me. And you'll hear all kinds of stories when you're walking the boundaries with these people, and talking to next door neighbors, and before there's an argument, before there's a problem, what do they all think? What are they all thinking about where these boundary lines are? And that was just my MO. And then of course over the ensuing 2 decades, I've read a lot of court cases where old timer was never found, but he ended up in court. The lawyers found him. And how do you find them? You sometimes you got to ask questions, especially if you got a problem on your hands. You need to ask questions. Well, who owned this property before you? And is that person still around? How did this boundary? Where did this fence come from? Who built this fence? And those kinds of questions. So the attorneys find them. Now, granted, the attorneys are probably getting paid a lot more doing the case than you are getting paid than you got paid for doing the survey. But there seems to be there's never enough time. As an old mentor of mine, my first head chairman, we called him his name was Gene Wells, but we called him Doc Wells. That's a long story. We don't need to get into that. But he said his famous line was, "There's never enough time to do it right, but there's always enough time to do it over."
Absolutely. So Kyle threw into the chat here, next roundtable Tuesday on March 25th, to keep working on my struggle in proving a few ancient PLS corners' existence. So join the next roundtable Tuesday there. So we've got existing corner, and then we've got obliterated corner. An obliterated corner is one whose point there are no remaining traces of the monument or its accessories, but whose location has been perpetuated, or the point for which may be recovered beyond a reasonable doubt by the acts and testimony of the interested landowners, competent surveyors, or other qualified local authorities or witnesses, or by some acceptable record evidence. And then a lost corner. A lost corner is a point of a survey whose position cannot be determined beyond reasonable doubt, either from traces of the original marks or from acceptable evidence or testimony that bears upon the original position, and whose location can be restored only by reference to one or more interdependent corners. And so that's that proportionment measurement only type retracements from the old geolo maps and that type of stuff. So, I mean, the first two are pretty broad in their definition. It would take quite a bit to get to that lost corner and upset the status quo. And I say that at our conference back in February, we were sitting in the hotel lobby after the conference. We were talking with a surveyor that works in a more rural part of the state, and he was complaining about all us city surveyors. It's urban, it's established. I mean, all the corners are basically in. There's township reference plats that even if the corner gets lost by some sort of construction or something like that, there's surveys and evidence that, I mean, we can reestablish that corner very precisely. And he was complaining about surveyors that come in and don't work in the more rural areas and will go just proportion in corners and be off 30 feet. And, he has to then go retrace our surveys. He goes finds the original stones in some of these areas that he generally works in. And, we go in there and we say, oh, it's lost. I can't find it. There's no evidence. And I'm just going to reset a corner. And again, the stuff we're talking about. And so a lot of that's just understanding where you're practicing, right? And understanding how hard it is to call a corner lost and just go set one so you can continue on your survey. It's not a lot of time to do it the first time, not a lot of money to do it the first time, but there's plenty of time to do it that second time because you got to get it right. You don't have to go redo it. Continuing on here, so 707, the best available evidence. Read right here, 6-14. The basic principle of protecting bona fide rights are the same in either the dependent or independent resurvey. Each is intended to show the original position of entered or patented lands, including the original description. The dependent resurvey shows them as legal subdivisions, the independent resurvey as segregated tracts. Each is an official demonstration by the Bureau of Land Management according to the best available evidence of the former survey. There is no legal authority for substituting the methods of an independent resurvey in disregard of identified evidence of the original survey. And the 2009 manual says, determination of the best available evidence of the original survey involves consideration of both direct and collateral evidence. Again, this is all just an evidence gathering procedure. Direct evidence from the record of the original survey should lead to the adoption of certain points as existent corners, while both direct and collateral evidence may lead to the adoption of other points as obliterated corners. The examination and careful consideration of the bona fide rights of non-federal interests may lead to further collateral evidence of the original survey, or may lead to a modification of the basic control of the dependent resurvey. And these concepts are more fully developed in Chapter VI. In fact, Chapter 6, the resurvey and evidence does contain a detailed discussion of evidence, including best available evidence. And so some great resources here, and I love the jump back and forth between the manuals and what we're doing. The manual to prove us, and we can't just pick and choose out of the manual what we want to apply. About 15 minutes here, so any discussion or questions about the best available evidence, lost, obliterated, or existent corners before we jump on here? I'm cruising through this a lot because it's somewhat kind of repetitive in what we're talking about, but it all proves its point. And I don't say that to detract from the book. There's some great evidence in here, but I want to keep the discussion going. Matthew, go ahead.
Yeah, I think Jeff was just about to get there in 3-137. It does start talking about bona fide rights, and I was hoping maybe he could go back and revisit and kind of finish that section, or at least expound on bona fide rights as evidence.
I was trying to talk, but I had my audio turned off. Okay, two trains of thought going on here. One is best available evidence. And the Northrop case, Northrop versus Opperman, has a good discussion on best available evidence. And Chief Justice Abrahamson said the best available evidence in boundary scenario is the deed and the original monuments. But when the original monuments come up missing, then you've got to go to the next best available evidence. And in that case, the next best available evidence, when nobody could satisfy or recover the original section corners, the next best available evidence was where did they build the road? They condemned when the monuments were in the ground, they condemned a road, 25 feet on each side of the section line, and they built a road. And so the road then became, and the acquiescence of the people then became the next best available evidence. And a lot of cases talk about this, and the whole GLO system, especially here in the southeast. Okay, here in the southeast, they drove in sticks, they drove in wood. Okay, and they didn't even have the surveyor generals for the southeast Mississippi territory, which includes Mississippi, Alabama, and for Florida and other southeastern states, weren't expecting those green sticks to last more than a couple of years. So what were they expecting to happen? They were expecting that the land would be sold by the federal government, and then the entrymen would move in good faith efforts to find their quarter of a section. If they weren't buying the whole section, then there were a lot of missing corners. If they were buying a 40-acre tract, there was a lot of missing corners. So they were the intent was, and the feeling was, what they thought was going to happen, they being the GLO, is people would buy their property, they would move in, they would exercise good faith in locating their property on the ground, and the stakes would eventually go away. But what would rise up uh, um, in place of the sticks would be the fences that they built, would be the improvements that they did. So that's why fences are just so ultimately important. You got to know why that fence is there, who built it, why is it there, what does it represent. You just can't ignore fences. That's a whole other long story. I've been through it all. I mean, there was through it all. Listen to me. I started surveying in the 70s, and I was there in the 80s and 90s and up till today. And there was a time when, being a fence line surveyor was a taboo. It was like, you're lower than scum if you're holding fences. You have to do the math. That's what Brown taught us. You have to do the math, and you have to, break stuff down, and you have to get in there and do it right. You can't be a fence line surveyor. But if you read that case, Northrop versus Opperman, they have these cases she talks about. They have these cases. They're called the fence line survey cases. They have so many of them. They have a name for them, where a survey comes along and there's been a fence there for 100 years, and the surveyor comes along and upsets the status quo. They have actually a name for it. So as far as, and I'm going to try to answer, who was it who asked the question?
Matt did.
Matthew. Okay, so I'm going to try to answer, and if I don't answer it, let me know. But so bona fide rights, good faith rights, are assigned to, are ascribed to the entryman, the claimant, or the patentee in an attempt of that landowner, that new landowner, to go out there in good faith, not fraudulently, but in good faith, to locate his or her lands on the ground. And the biggest missing corner was the center quarter, because they set all of they set the 4 section corners, and they set the 4 quarter corners, and you got to get that center quarter. So as long as they did it in good faith, and how much more good faith could you have than hiring a local surveyor to go do it? Even though the surveyor might have stubbed it in, might have stubbed the center quarter in, might have done just like Derek did, just stubbed it in running one way. Um, you know, how was that bad faith on the part of the entryman who hired Derek to go out and set the center quarter? That you can't ascribe bad faith to that entryman in that way. And so bona fide rights and good faith efforts are charged to the entryman, the original patentee, or the claimant, or the entryman, not to surveyors. And we have completely flipped that over, and I was around for all of that. We completely flipped that over to ascribing good faith efforts to a surveyor following proper procedure. There's nothing in the manual that says surveyors have to follow proper procedure. I read you from my little bit of a slideshow here. The federal government has no control over local surveyors, no control whatsoever. And if a person owns an entire section of land, there's no requirement that landowner follow any kind of procedure on subdividing their land. The federal government has nothing to do with it. When the land goes out of the ownership of the federal government's done, and now it's private property. And now there's such things as and there's property rights. People have rights in these properties. They're called property rights. And you can't, and there's this other thing, it's called the Constitution of the United States. You can't have, as a citizen of the United States, which every state, the citizens of every state are also citizens of the United States, cannot have their rights adjudicated without due process of law. But surveyors are out there adjudicating property rights every day, and they're not doing a very good job of it every day. And we know who they are every day. So that's where we are. Did I answer your
Matthew, does that answer your
question?
question?
Did I answer your
Yeah,
question, Matthew?
thank you. I just wanted your perspective on the bona fide rights and how that pertained to public lands. Thank you.
Okay, Kyle, you got your hand up. Go ahead.
Yeah, so when you are experiencing, well, basically two different surveys that have been relied upon, I've got a situation right now where center of the section, two different people have established that center of section two different ways. And so is it reverting to, hey, this guy did the good faith thing first, or am I going to be putting two centers in the section, the center of this section, and they're 50 feet apart because they both stubbed in different directions?
Well, generally speaking, and the manual supports this. I've read some of that already. If it's already set, you're not supposed to set another one. And there are other court cases that I've read across the country. Generally, and then there's also equity, first in time, first in right. Generally speaking, the first monument out there should be the one that the rest of us are holding. Why in the world you already have a monument in the general vicinity of the center quarter? The only reason you're going to set another monument in that ostensibly for that same corner is because you're being dictated by math. You're being dictated by a formula. You're being dictated by math and measurement. The lowest form of evidence, the lowest is acreage. The one below that, the one just above that would be either bearings or distances or bearing measurements. Measurements are the lowest form of evidence. And unfortunately, too many surveyors elevate measurements to a higher form of evidence because they can do the measurements, but they're not sure about their judgment call. And that's what I'm writing on currently in XY HD magazine is how do you know your judgment's correct? There's no mathematical formula to check your judgment, but there is a mathematical formula for checking your closure and your measurements. So we've been a measure-centric profession for a long, long time. We love our measurements. If our measurements get don't like, I mean, we're quick to jettison everything but measurements when all of the rules of the road all of the rules laid down, the rules of construction, the boundary location doctrines. Basically, the measurements are the lowest form of evidence. They tell us this time, the courts tell us this time and time and time again. We just think it's like a fairy tale and it doesn't really happen, but you know, it does happen. The courts look at that and they're looking for the best available evidence, and it's not going to be your measurements. Again, read Northrop versus Aquaman. Download the whole thing. Read the entire thing. It is just it's mandatory reading. It should be mandatory reading for any surveyor who's who wants to really understand retracement surveying. And another problem we have, and I'll just keep going here for a couple more minutes. Another problem we have is the courts use very imprecise language, and I know where that language came from. The language has come from the federal government and the GLO, and all these manuals that have been written over the years. The courts just didn't come up with the term resurvey. They read it somewhere. What is a resurvey? It's not the more precise language would be, I'm doing a retracement survey. I'm not doing a resurvey. And establishment. Survey. We talked about this early, a few weeks ago, or early on in this program. Establishment. The courts use that. Well, the BLM manual uses it. The GLO manuals used it. They use resurvey. They use that term, but establishment. Boundaries surveyors don't establish boundaries. Surveyors don't establish anything. We play a role in establishment, but the people, ultimately it's the people. It is the people. It's their activities and inactivities that establish boundaries. You can be an original surveyor and you run out there, you're subdividing a 40-acre tract and you put all the pins in the ground. And so you establish those boundaries. Not necessarily. There's only one scenario in which, when the monument was set, the corner became established, and that was the GLO scenario. And that's all because of the Act of 1805. That federal act, it's now codified. It's been codified for a long time, but the Act of 1805 said, wherever we set the monuments, that is the corner. There's no question about it. Now, there are other states, Georgia, they had a landlocked system. Texas had a general land office, so maybe they have something similar that they've set up in their statutes. But as far as the common law is concerned, there is only one, that I'm aware of. There's only one instance when the original surveyor sets the monument and the corner are one in the same, and that is the rectangular survey systems, public land survey systems, because it was codified. It was codified by the federal government. Nowhere else is it codified that if you're out there working in private practice and you're subdividing 40 acres, you may be the original surveyor, but that's only if everybody goes into, if all the landowners come in and they glom onto those corners and they go into reliance on those corners, and then those lines in those corners become established. That's how they become established. So imprecise language, our courts use it. We're kind of stuck with it. There's other examples, but those are the two right off the top of my head. Establishment and resurvey. When really what is meant is retracement survey.
Okay, real quick, Dave, you got your hand up, and then I've got one thing to kind of answer and add to Kyle's question there.
Yeah, I'm gonna try to answer Kyle's question as well. The way I've handled this practically is, assuming that neither of your center section corners are you can determine that they're original monuments. If they're both retracements, you don't know which one to use. I usually hold the bigger pipe. No, actually, I would try. I would look at
the weighted method, David. Right? The weighted method.
I would look at you know, there's a lot of consideration there. You got to look at occupation. Well, first of all, who was there first is certainly good evidence. What are the people occupying to? Which one have they accepted over time and establishment? Um, and then uh, I'd kind of factor in all these things, and then if I really can't figure it out, well, so first and foremost, let's avoid the calamity of the land surveyor, right? I'm not going to go in and draw a line through a house or call off all the fences or all that kind of stuff, and that's kind of just my general attitude going in there. And then I would, you know, if I can't make a determination, I would talk to the interested parties on each side of the line and say, hey, what do you guys? Which one of these do you guys like? Can you accept one or the other? If they can't, then you're going to have to make a call. Um, Usually, my experience is people just want to come to an agreement and work this stuff out, unless there's a lot of money on the line or several hundred feet of land. But hopefully, you don't have a huge financial discrepancy here. So, I would just look at all the factors and come up with a reasonable solution and equity. Use that term equity and figure out what's fair and what the people can live with, and then just put that on your map and say, this is why I did it. Be able to defend your solution and walk away. You'll be able to sleep at night after that.
And I'll throw this on here real fast. I agree with what Dave said. This is one that I've tied to quite a bit in an area that I work in, but I really love the tie sheet to this monument. Now, some of the actual physical monuments are no longer in the ground, but you've got monument position from about 1960 to 1983. You got monument from 1983 to about April of 1998, and then corrected location as of 1998 to present, which this tie sheet was done in August of 2000. And so local practice for this, it all depends upon when the deeds or subdivisions were done. And so you're actually going back in time to see who tied to what when. And so maybe in the case of a multiple monument, like you shared, is the north half of the section is tied to one and the south half of the section is tied to another. And you kind of have to gather that evidence to see how and when they've tied to them. That's kind of been the general practice for these ones, because there's been a time frame for each one. And if you respect that time frame and look at it and not try it to one monument or the other, everything actually fits really well. And there's harmony between everything, but it's when you tie a deed written in 1965 to the 1983 monument, all of a sudden nothing fits, and you could throw confusion in there. But if you can look at time and occupation and all that other evidence, everything in this case fits really well. And so it's an interesting practice in the multiple monument conundrum there.
Yeah, that's all helpful. I just find more and more, my choice is not whether or not I'm gonna, accept a monument. It's which of these monuments am I going to accept? Because at this point, the pincushions are out there already, and now the job, the sequel to Pincushion Effect could be, multiple monuments and that trash you're going to wade through going forward.
There you go. The what next, Jeff? That really should be your next book. Is you found it, now what do you do with it? Someone else has screwed it up. How do you fix it? I think this gets us. I mean, we're past the hour here, but just to finish out chapter 7, really put a big bow on this. The last page of chapter 7, and we're talking about, or what's the header of this section here? It is, I turned the page here, so the further subdivision of sections we've really talked about. That's not needed. There's some good cases and language in here, and Jeff touched about it in his presentation, but repose. Repose is a well-established doctrine of the law and equity, and a strong supporter of the status quo. Mere technical errors are not enough in the estimation of the BLM to upset established boundaries. To do so will create interminable controversies. I think the writers of the new 2009 manual read Cooley in their spare time. Once subdivided, always subdivided. Some admonitions from the pamphlet, restoration of lost or obliterated corners and subdivisions of sections, a guide for surveyors, are appropriate for wrapping up this chapter. I don't want to read all this, but I agree with Jeff. From everything we've talked about these last 4 paragraphs here, that's your guys' homework, is to go reread those in light of the discussion tonight. And I think that's a good wrap up for chapter 7.
And the new book is called Multiple Monument Dilemma.
I like it.
Well, if I get to it real quick, Trent, we could do it. We'll make that the next book.
Right?
Get it written over the summer for us.
Yeah, you'll get it done. You'll get it done.
All right. Well, I had a great time, guys.
Yeah, thanks everybody.
Guys and gals.
2 weeks. We'll be back in 2 weeks. So the week of there'll be all 3 of them again the week of the 24th. So we'll do mentoring, a roundtable, and wisdom 24, 25, 26 of March. So.
Okay.
All right.
Perfect.
Guys,
Thanks, everybody. Thank you.
Awesome. Bye, guys.